Hello, everyone. Welcome. My name is Kristen Bauer. I'm the head of policy here at the Chartered Institute of Arbitrators. I would like to welcome you all to this webinar, 2024 in Focus, Charting the Course for 2025. Thank you all for joining us from all corners of the world. And thanks so much for all of you joining and chiming in the chat already. So today we have a wonderful panel of experts with us who are joining from all corners of the world. They are going to recap and highlight some of the major developments in alternative dispute resolution over the past year, as well as help us understand and start to anticipate, some of what may lie ahead for us this year in the industry. We've structured this webinar in two parts. So in the first half, we're going to hear from each of our speakers, and they'll provide an update from their respective regions or jurisdictions. In the second half of the webinar, we're going to change gears a little bit and have a more of a Q&A style roundtable discussion on cross-cutting topics and trends in three areas. So we're going to look at ethics and standards, climate and sustainability, and technology and AI. So before we get started, I would like to give the floor to each of our speakers for them to introduce themselves. So just looking at my screen, Caroline, why don't you kick things off?
Hi, good morning, good evening. My name is Caroline Thomas. I'm based in Hong Kong. I'm an arbitrator and a lawyer with Hausen LLP in association with Angia Chinese law firm and DWF, mainly doing insurance. And I'm also on the committee of Ciarb East Asia branch. Thank you very much for organizing this.
Thank you, Caroline. Richard?
Yes, thanks very much. It's a great privilege and pleasure to be here with such distinguished colleagues. I am a chartered arbitrator and past chair of the New York branch of the Chartered Institute. And teach international arbitration law at Fordham Law School and at the Columbia Law School Ciarb course on international arbitration. Pleasure to be here.
Thank you, Richard. Christina?
Hi, everyone. It's such a great pleasure to speak to this international audience. My name is Cristina Wagner Mastrobuono. I'm an independent arbitrator based in São Paulo, Brazil. I'm the chair of Brazil branch and very happy to be here.
Thank you. Zaina?
Hi, everyone. I'm truly delighted to be part of this webinar and very distinguished speakers. My name is Zena Obeid. I'm based in Dubai. I'm a fellow of the Ciarb and member of its committee of the UAE branch. I'm a partner at Obeid and Partners, where I practice in the arbitration department as counsel and as an arbitrator. So it's great to be here with all of you, and thank you for organizing this, Kristen.
Thank you so much, Zaina. Professor Githu? Oh, Professor, you're still on mute. There you are.
My name is Githu Muigai. I practice law in Nairobi in the law firm of Mohammed Muigai LLP, where I'm a founding partner. Most recently, I've devoted most of my work to arbitration, both as counsel and as an arbitrator. I have an academic interest. I am professor of public law at the University of Nairobi, on leave of absence the last couple of years since COVID, so to recoup. And I'm very happy that I'm able to participate in this webinar.
Thank you so much, Githu. And last but not least, Philip.
Thanks, Kristen. Philip Landoltz. I practice international arbitration with the Geneva law firm, Landoltz & Koch. I've been doing so for the past 25 years or so. I am the European branch president of the Chartered Institute and a fellow of the Chartered Institute. Yeah, I too am very happy to be involved in this this interesting discussion.
Excellent. Thank you again so much to each of you for joining us today and sharing some of your insights and expertise. We greatly appreciate it. So just a bit of housekeeping from my side before we jump into the discussion. So first, this webinar is being recorded and the recording will be available on our YouTube channel following this event. Second, this webinar will be followed by a special issue of Ciarb's Resolver publication that will feature written pieces of work from each of our wonderful panel of experts today. So please keep your eye out for that publication coming here in the next couple of weeks. And finally, we want this whole discussion today to be interactive. So for all of our participants who are online with us today, we have a couple of ways that you can interact together throughout this webinar. First, as many of you have seen, we have a chat box function that's available to you. If you click on the blue box that says you're communicating with everyone, you can interact with the speakers and with other participants online, and we really encourage you to do that. And we have a second way that you can interact, which is you should see a question and answer function on your Zoom screen. And so we encourage you to add questions either to the chat or to that question and answer box at any time throughout our discussion. And I'll be monitoring the chat, trying to pull in your questions into this group, as well as our speakers. They will have an opportunity to respond to you kind of in kind as you raise questions in those two areas. So with that housekeeping out of the way, I'm going to dive straight into our regional updates, and I'm going to give the floor to Philip to take us through a look at what's happening in the EU and the UK. Philip?
Thanks, Kristen. Yeah, so the EU and the UK, quite a lot happening. I have announced that I'm going to be speaking about the reform of the UK arbitration law, the reform of the German arbitration law, and also, as we phrased it, EU threats to international arbitration, somewhat polemically, I suppose. It's actually that third topic, which I think is probably the most engaging, probably the most complex, and probably the least well-known. So I'd like to focus on that principally. Nonetheless, I will say a few words about the two other topics. In this, I won't really go into the substance of the proposed amendments. I think they're well known. I'll mention one or two things, but I will look at the state at which they are, when they're likely to come into force. And I'll compare, if you'd like, the methodology between the two countries in arriving at these reforms, which I find fascinating. UK arbitration reform, as you know, the 1996 Arbitration Act is of some vintage. Everybody agrees it has worked well. And therefore, there's a high degree of consensus that it never did need root and branch reform. It really just needed to be tweaked. And that's exactly what's happening. Everybody agrees that there are very few issues, and one finds this in the report of the Law Commission, which says just that. We're just going to look at very few issues. The final report of the Law Commission is basically flowed into what it looks like will become the final statutory form. And in effect, the big change is going to be a stipulation on the law applicable to the arbitration agreement. As you know, under the case of ENCA and Ciarb, you've got a situation where essentially the applicable law to the arbitration agreement is going to be the law applicable to the contract around it, other things being equal, where there's, for example, no choice of the law specifically applicable to the arbitration agreement. Is that a good thing? It probably is, although the reasoning in ENCA and Ciarb is very good. The position is perhaps a little too sophisticated and difficult to predict. This is going to simplify it. And also it's going to make the applicable law a little easier to apply, in as much as you're going to get a situation where the court of the seat is going to be effectively applying its own law under this new rule in the proposed reforms. So that's a positive thing. But one might think a negative outcome would be one will probably see fewer anti-suit injunctions to protect international arbitration. And here's why. Generally speaking, the English court is quite robust in its protection of arbitration where the applicable law is English law, because who knows better what English law entails than the English court itself. But where you've got the applicable law, the law applicable to the arbitration agreement being the law of the seat, you're not going to get the English court so frequently, issuing anti-suit injunctions where the seat is outside of England and Wales, as you saw in the Unicredit and Roskam case, the very famous recent case, where the English court granted an interim injunction protecting international arbitration in relation to an arbitration seated in Paris, France. On the application of the Enke and Ciarb rule, that you've got English contract law and therefore English law applying to the arbitration agreement. So that's one big change. There are others. I'll mention that the statute is likely to come into force sometime around, well, the first part of this year, and that's because it's currently at second reading, and there have been no amendments proposed. So that's a sign. But also, as you know, it started out under the previous administration, and that, of course, died on the order paper on the 4th of July, 2024, with the national elections in the UK. But as you know, it was reintroduced in the speech from the throne on the 24th of July, 2024, with the result that nobody's opposing it. So, it's going to, I think, see the light of day in its present form in the first part of this year. So let's turn quickly to the German reforms. The German reforms are similar. They're not root and branch. As you probably know, German arbitration law is in its civil procedure statute, chapter 10, and it's based on the model law. In fact, it's based on the 1985 model law because the German statute comes from the 1990s. So it really has stayed in this sort of form, this aspic form, since that time, and consequently, it does need some tweaking. And you're going to get some similar things to what you see in the United Kingdom reform. For example, the institution of emergency arbitrators developed subsequent to the 1990s, as you know, and so both reforms are going to grant powers to the courts to enforce the orders of emergency arbitrators. That's just an example. The German statute is going to do a number of other interesting things to bring it in line with the more modern version of the Unstrom model law, the 2006 version, which is in particular to remove all formal requirements for the validity of an international arbitration agreement. That's fairly radical. Very few major arbitration systems accept this. Well, France does, as you know. It is an option under the 2006 model law, Unstrom model law. So it's not entirely extreme, but it is a matter of some commentary in German legal circles. The German legislative provision is also making its way through Parliament, and it's expected to pass also in the first part of this year. I'd like to discuss, in the limited time available to us, the methodology by which the two countries came to these legislative reforms. The thing about the UK legislative reforms is that they have been subject to such public discussion and consultation. I mean, it's extremely broad. And I think it's down to the use of the Law Reform Commission. That didn't happen in Germany. And what happened in Germany is you've got a white paper. It's something called the Eckpunkte or something. That means the cornerstones of the corner points of the proposed reform, which the Ministry of Justice itself put out. But in the UK, as you know, the Ministry of Justice in 2021 asked the Law Reform Commission to study the question. And the Law Reform spent a good year doing that and consulting with people and came up with with a draft report and continued consulting. And finally, it came up with its final report. The thing is, of course, that final report, based on very, very broad consultation and therefore consensus, I mean, it quotes many, many commentators. It's actually absolutely extraordinary. And it really is if you'd like, a very welcoming and inclusive process, a very broad church, one might say. And you see there that everybody's converged onto essentially the same approach to reform, with some few elements of disagreement. So in Germany, what happened, as I mentioned, you get this white paper, which is more or less appears, as fully formed like Athena from its father's head, the parliament. And this is commented on, yes, by various authoritative commentators, in particular the DIS, the Deutsche Institution für Schiedsgerichtsbarkeit. Now, you probably know them. They're such an important force and presence in German arbitration. But you tend to feel that, I suppose, like Switzerland, where ASA did the same thing in regard to our 2021 reforms, it is a sort of top-down approach. Nonetheless, here's the thing about the German situation. It is a model law jurisdiction. So there's, if you'd like, an awful lot of opinions out there. And everybody knows how the thing works around the world. And there's probably less need, therefore, to consult on it. Everybody more or less agrees on the inadequacies of the model law, even in its 2006 version. Vis-a-vis the current state of play in international arbitration. So I don't want to criticize, but I found the UK approach so very rich, and I think ultimately it's going to prove to be very, very robust. There is a very healthy, vigorous discussion on international arbitration, which I don't see to that extent in Germany. And both are seeking to modernize their arbitration laws, and in particular to make them more attractive. And so I think what Germany ultimately did is very attractive. They've done some extraordinary things. They've looked at things like making publication of awards more broad, making the courts more sensibly support international arbitration, et cetera, et cetera. So I think ultimately they got to the right result, but I do wonder about the process. That gives me a few minutes to speak about EU threats to international arbitration. Well, everybody knows about Achmea, Comstroy, PL Holdings. In these decisions of the Court of Justice of the European Union, the court determined that intra-EU arbitration agreements were invalid because they are contrary to the principle of autonomy of EU law. What does that mean, invalid? It means effectively that the EU is treating them as inarbitrable. Okay, they just cannot be subject to arbitration. The rest of the world says that's not right. Why did the EU decide that? It's because the EU court's chief mission is actually to enunciate the constitutional law of the EU. All right, that's a very, I think, a very significant point. So the EU court, the Apex court, is saying this is what the EU law requires, and we're not so much concerned about how that is going to affect, the EU member states' obligations under public international law. And that is the rub. That's where the problem arises. Under the EU system, it's up to the EU member states to bring their law, including the public international law they've accepted, into compliance with EU law. And so you've got, if you'd like, two ships passing in the night. You've got the EU saying these arbitration agreements aren't any good, and you're under an obligation, you EU member states and your courts in particular, to make sure they're given no effect. There's a specific statement in EU case law on that very point called Romatza. And the rest of the world, including Switzerland, is saying, no, those are perfectly good arbitration agreements. You can't cite your own law to vitiate an arbitration agreement, et cetera, et cetera. This is, of course, a threat to international arbitration, but it's a limited one because it only affects a small, discrete category of arbitration agreements. Well, potentially we can ask ourselves whether this concern about autonomy is broader and would in fact commercial arbitration and sports arbitration. Nonetheless, I'll say two words about what's currently being discussed, or what the current skirmishes are in relation to Achmea and its progeny. Well, the first one is there's an awful lot of anti-suit injunctions. So the EU is encouraging, well, I suppose that's not right. The EU member state courts are asking themselves whether it's a requirement of EU law to interfere with the effects of arbitration awards under intra-EU arbitration agreements. And as you probably know, civilian states, most of EU member states or civilian legal systems, don't really have this institution of anti-suit injunctions. So you don't get like a very forceful movement in that regard. Nonetheless, recently, German courts have started to exercise powers which allow them, before an arbitral tribunal is constituted, to declare the invalidity or scope of an arbitration agreement. And so, at least on one occasion, a Berlin court has declared that what was happening outside of Germany is actually not compatible with German law because it's not compatible with EU law. And this is, I think, as far as civilian legal systems will go, a declaration. It won't seek, as the English courts do, to interfere with the proceedings, with the parties' actions in proceedings abroad. That's the first thing that's happening with regard to intra-EU arbitration agreements. Another thing that's happening is, in a case called Mikula, it was decided that the mere fact of enforcing an arbitration award, which is contrary to the EU state aid agreements, is in fact contrary to EU law. And there's a case that was decided by the General Court, as you know, that's the lower instance of the European Court of Justice. It's now before the higher court, the highest court, the ECJ, the European Court of Justice, and I think the expectation is that the first instance, the General Court's view, is going to be confirmed, such that if you've got an international arbitration award which is in violation of EU law, in particular state aids, there's a requirement on EU member states not to give it effect. Okay, so that's the first thing. More interestingly, and this is the very last point, perhaps the most important one, in terms of threats from the EU to international arbitration, is a series of two sports arbitration cases. The second of these is actually going to answer our question whether the requirements of ACMEA will give us some indication of whether the requirements of ACMEA may actually extend to commercial arbitration and sports arbitration. The answer in this case, a mere opinion from the Advocate General, is no. But in two cases involving sports arbitration, you get, if you'd like, more requirements from the EU interfering with international arbitration. The first is one called the International Skating Union and the Commission. And in that case, you had skaters who were deemed by the ISU, the International Skating Union, to be ineligible to participate in ISU events, which basically is, all the events, because they organize all the important ones, the only ones that matter. And the European Court of Justice, on a preliminary reference under Article 267 on the Treaty on the Function of the European Union, actually said that there's a real problem, in as much as these people don't have an opportunity for review of their case before EU member state courts. And here's why. It's CAS arbitration, and as you know, CAS arbitration is only it's seated in Lausanne traditionally, Lausanne, Switzerland, and therefore it's only reviewable by the Swiss Supreme Court. CAS arbitration also says that there's no interim measures outside of the CAS arbitral tribunal itself. So any recourse needs to go through the CAS arbitral tribunal and then up to the Swiss Supreme Court, and that's the end of the story. The court, the ECJ in ISU, said that is a violation of the requirements under the EU law to have the availability of preliminary references. That has to be available. So effectively, people are understanding this case as requiring that, at least some category of arbitrations needs to be seated in the EU, because, as you know, you only get preliminary references from EU courts. Yeah, effectively from EU courts, EU member state courts, I mean, sorry. So that's actually a big threat, isn't it, if that's what the case is actually requiring. Kristen, are you motioning to me that I've overstepped my time? No, I've got a few more minutes. Great. Okay, I am getting towards the end. So that's one potential reading, that you get in every sports arbitration this requirement effectively that the seat has to be within an EU member state. Big restriction, isn't it? Problem. Is that compatible with the New York Convention? Now, interestingly, in this decision of the ECJ, there's no mention of the New York Convention. It's sort of, this whistling past the graveyard. And again, the ECJ is a constitutional court. Its first concern is the requirements of European Union law, and it leaves it to the member states to fall into compliance in accordance with what it deems EU law to say. Well, it's right, isn't it, that the New York Convention requires its signatories, all 27 European Union member states are signatories to the New York Convention. This convention requires the recognition of qualifying arbitration agreements. And, with some few exceptions, and those simply are not satisfied in this case. How can it be that an arbitration agreement, which is good if the seat is in the European Union, is not good if the seat is outside of the European Union? So it's a real New York Convention problem. I say myself that I think this is a reason to read down the import, the holding in ISU, and to say it only actually applies in situations where you've got a lack of internal, let's say, independent internal review of the ISU transfer eligibility regulations, and that's what the ECJ found. It said that you don't even have an internal review within the ISU. You don't have a panel that's independent looking at the decision. You have no review. The ECJ says that's a problem. That's the main problem, and the lack of external review to an EU member state court is actually an exacerbation. They say it reinforces the violation. So that it was possible to read down ISU as requiring only an internal review, an independent internal review. But that's no longer the case, potentially, in that in the second case called Royal Football Club Serang versus FIFA, on the 16th of January, 2025, very recently, just after 2024, but, for our purposes, still, obviously a recent legal development. The Advocate General, who is Timerek Šapeta, it's a Croatian name, I'm not sure I'm pronouncing it right. Richard might be able to assist here in due course. At any rate, this as you know, opinions of the Advocates General don't bind the ECJ, but they're often followed, probably more than 50% of the time, and they are quite influential generally because they, unlike the decision themselves, they tend to range more widely in explaining EU law. Well, the Advocate General is faced with this situation. You've got restrictions under the FIFA regulations on taking an economic interest in players, and in particular their transfer. So on the facts here, there was a company based in Malta who took an economic interest in the transfer of some players. If the players are transferred, they get a certain amount of money, and they obviously pay in some money and assist in some regard. I think it's basically assist the clubs, get them a source of financing, against or in consideration of ultimately receiving money if the player is developed and attracts a new employer. At any rate, so you can see that engages all sorts of EU law questions about free movement of workers and free movement of capital and free movement of establishment, and also EU competition law. So all those questions are engaged, and it's right that they're big questions. They are the pillars of EU law. They're fundamental EU law. But we're going to see that what AG Šapeta recommends is that for all EU law, you're going to need, in particular cases, you're going to need review by EU member state courts, which is quite fascinating. So she says that the concern here is, three things. She says it's the right to protection of EU law rights under Article 19 TEU, the Treaty on the European Union. Okay, protection of individuals' EU rights. They have a right to have these protected by the courts of the European Union member states. Secondly, there's a concern about the availability of these preliminary references to the ECJ under Article 267 TFEU. And thirdly, there's a concern about the right to a legal remedy and the right to fair legal process under Article 47 of the Charter of Fundamental Rights of the European Union. So you've got all these concerns. And she says, unfortunately, whereas in FIFA arbitration, CAS arbitration, you don't get access to EU member state courts, you've got a violation of these three requirements under EU law. And she's categorical about it. And she says, it's not every situation where we're going to find ourselves in this position, but it's where, as here on this case, you've got athletes who don't actually choose freely, in her opinion, don't freely choose arbitration, because if you want to play football under the auspices of FIFA, which is any good football or any prestigious football, you need to accept its regulations. And within those regulations, there's a requirement of CAS arbitration. And she says, secondly, and I think quite interestingly, insightfully, I have to say, she points out, and this hasn't been pointed out, wasn't pointed out in ISU, but I think it's absolutely true. She says that FIFA arbitration awards, CAS arbitration awards involving FIFA are actually self-executing in as much as FIFA just excludes you from playing if you don't comply with them. So they never actually get enforced. And therefore, there's never this opportunity to come before European Union member state courts to get a review, even on that limited public policy basis. And you recall the ancient case, the old case of Eco Swiss and Benetton, where the EU said through its ECJ, we're fine with the general infrastructure of international arbitration. You've got this opportunity to review at the enforcement stage under public policy. And as you know, that mirrors what the U.S. Supreme Court said in the famous 1985 Mitsubishi case, and Solar, And that, of course, left international arbitration unmolested. But now we're getting quite a different situation. And she's saying, because of these two features in sports arbitration, she says all sports arbitration, I think it's probably just some sports arbitration, but much of it. Number one, you're not going to get free acceptance of arbitration agreements. You can debate that. The European Court of Human Rights in Pechstein and Motu was much more circumspect about that. And secondly, you're not going to get any real enforcement. So you're just not going to get that athlete having an opportunity to come before the EU member state courts, with the result that there's a violation of Article 19 TEU, Article 267 TFEU, and Article 47 of the Charter of Fundamental Rights. And she says, therefore, you cannot have the effect is you cannot have this sort of sports arbitration, maybe sports arbitration altogether. That's what she seems to be suggesting, outside of the EU. It's quite extraordinary. Does that actually concern anybody other than Switzerland? Probably not, because most sports arbitration is CAS arbitration, isn't it? And that all goes to Lausanne, except FIFA recently amended its statutes to allow a choice of arbitration in Ireland. Okay, so they think they saw this coming. All right, but in general, if we have a situation where those two factors are present, you're going to need arbitration effectively in the EU, because that's the only way you get review. She says, interesting, last point, that ACMEA and its progeny are not engaged. Very, very interestingly. And it's because she does something quite extraordinary with ACMEA. She says it's not so much about the autonomy of EU law. It's about this principle, which is a fundamental principle of EU law called mutual trust between member states. And that's, if you like, a fundamental principle. It's not enunciated everywhere, but it does flow from Article 2 TEU. And anyhow, the basic idea is that you've got this group of people, and like full faith and credit, I think, Kirsten, in the United States, they all have to sort of, treat each other as equals and have trust in each other. And she says that ACMEA, offends against that, because you've got a situation where they're each saying, we're not going to trust your courts to deal with our investment problems. This is that cynicism of, if you like, diplomatic recognition. That's that kind of model. And they don't like that. And Cepeda, Advocate General Cepeda, says that's what's actually operating in ACMEA. Interesting. And she says, because of that, you don't get that violation with regard to sports arbitration. You don't get that violation with regard to commercial arbitration. So she kind of just, although she does say very firmly, we've got a problem with sports arbitration, all sports arbitration, she says very firmly, but that's the outer limits of it. Very, very interesting. I think one of the most important developments in in arbitration. You know, I've obviously summarized and glossed over much, but that's perhaps all I should say on it, given the confines of time.
Thank you so much, Philip. Fascinating. I was holding myself back. I have so many reactions, but in the interest of time, I'm gonna, switch gears across the Atlantic and head to Richard for some updates from the United States.
Thank you, Kristen, and really phenomenal presentation, Philip. Thank you for that. The focus of any update on arbitration in the U.S. usually is on judicial developments. And in international arbitration, this means the U.S. Supreme Court decisions and the decisions of intermediate federal courts of appeals, the circuit courts, with jurisdiction over the more active arbitral seats. This year is no exception, even though it is the 100th anniversary of the enactment of the Federal Arbitration Act. And the only major legislative updates to the FAA have been the addition of the New York Convention and the Inter-American or the Panama Convention. The smart money, I think, is on continued evolution of arbitration law through federal case law precedents. It's not on any sweeping legislative measures. Even though there is reason to consider President Trump to be pro-arbitration, the new administration and Congress are likely to be preoccupied with other matters considered more pressing, particularly given the strong pro-arbitration tendencies of the federal courts. Given the time constraints, I'm going to limit my discussion of case law to one Supreme Court case that's been teed up for 2025 and one circuit court decision in 2024 that's likely to be cited and quoted around the U.S., quoted to arbitrators and to reviewing courts. So the Supreme Court is set to decide in 2025 the question whether due process requires a showing of minimum contacts of a foreign sovereign or state instrumentality award creditor, that is, minimum contacts with the forum being asked to enforce the award before an international award can be enforced against it in that forum. The Ninth Circuit's ruling that minimum contacts were required arguably conflicts with other circuit courts, which have ruled that the minimum contacts are not required for recognition and enforcement of a New York Convention award. The case is CC Divas Limited v. Antrix Corp. And a companion case. Given how narrowly the question presented has been framed as a Foreign Sovereign Immunities Act question with no mention of the New York Convention, the court might not reach the New York Convention analysis and may decide the case based entirely on the question of personal jurisdiction of foreign sovereigns under the FSIA. However, a persuasive amicus brief, I think it's persuasive, filed on behalf of Professor George Berman of Columbia may result in some attention to the New York Convention analysis, which Professor Berman has framed in, I'm really oversimplifying, but I'll summarize the question as whether the U.S. courts can graft onto Article 5 of the New York Convention a requirement that a sovereign award debtor must have minimum contacts with the jurisdiction of the enforcing court. The circuit court case that I'd like to mention is the Seventh Circuit, which sits in Chicago, upholding a tribunal's award of attorney's fees as sanctions against respondent for having raised frivolous defenses in an arbitration that resulting in delay. That's the American Zurich Insurance Company v. Sun Holdings. The tribunal ruled against respondent on the merits and awarded attorney's fees as sanctions, notwithstanding language in the arbitration agreement prohibiting the award of damages in excess of compensatory damages, and a provision in the agreement requiring each party to bear its own fees and costs. The Seventh Circuit held that the attorney's fee award was compensatory. The decision reiterates the broad powers of an arbitral tribunal and the narrow scope of judicial review in ringing terms. It's reasonable to expect that several lines in the decision will be quoted, including here's one: the American rule, each side pays its own lawyers, is not understood to forbid sanctions for frivolous litigation. An arbitration clause delegates interpretive powers to the arbitrators. We do not ask whether they read the contractual language correctly. It is enough that they tried to apply the contracts that the parties signed. Another is that arbitration cannot expedite and reduce the cost of dispute resolution if the parties must litigate once before the arbitrators and again in court. And my favorite quote: whether the arbitrators were right or wrong is none of our business. Which, of course, this is Judge Easterbrook, who's famous for his clarity of expression. So let me transition to some developments that in the field of guidance that I think are worth mentioning. In 2024, the International Commercial Disputes Committee of the New York City Bar Association issued a report based on a comprehensive survey of awards issued in cases seated in New York. The report was on cost allocation practices. The bottom line, the ICDC found that arbitrators were not bound by do not consider themselves bound by the American rule. Again, the American rule is that can be varied by agreement in advance of the dispute in any case. The ICDC concluded that loser pays is a principle being applied in practice in the overwhelming majority of international arbitration studied, consistent with international arbitration practice around the world generally. But perhaps the most forward-looking development in guidance in 2024 is the Silicon Valley Arbitration and Mediation Center's guidelines on the use of artificial intelligence in arbitration. And I know that we'll be discussing artificial intelligence later. By way of background, for those who may be in jurisdictions where artificial intelligence hasn't become the burning issue of the day yet, AI appears to be playing an increasing role in the initial stages of selecting arbitrators, where AI can select vast amounts of data to identify the most suitable arbitrators based on their expertise, past rulings, and even potential biases. It's being used in exchange of information in the run-up to the hearing, in the preparation of memorials and memoranda, and perhaps in the drafting of awards and briefs. The perceived need for guidelines standardizing or at least rationalizing the use of AI in arbitration began to become clear in 2024, if not earlier. The Silicon Valley Association guidelines address AI in terms that should be familiar to even those of us who are not sophisticated in technology, including the duty of competence or diligence, the duty to preserve the confidentiality or privacy of proceedings, duty to protect the integrity of the evidence, the duty to avoid excessive delegation, decision-making responsibilities, and the duty to protect the fairness of arbitration. These guidelines seem likely to frame professional responsibility discussions around AI for some time to come. And I should add that AI has become a focus of thought leadership at all the major institutional providers, law schools, and bar associations in the United States. For example, the American Arbitration Association President Bridget McCormick is a special advisor to the American Bar Association Task Force on AI. So everyone is focused on this issue, and I think we'll be hearing a lot more about it in 2024. And I think I'll stop there.
Thank you so much, Richard. All right, now I'm going to move across another ocean, the Pacific, heading towards the APAC region. Caroline, over to you for some updates from from Hong Kong, Singapore, and the whole broader area.
Thank you very much, Kristen. So APAC is pretty big. I am going to restrict myself a little bit to sort of Greater China and Singapore and Malaysia, if I may. So one of the things that we've just heard is that many jurisdictions have arbitration laws based on the UNCITRAL model law. And that is actually also true in many jurisdictions in Asia. So for example, Singapore, and Hong Kong and Malaysia are model law jurisdictions. We have quite a bit of legislative change coming up, and we have two major sets of rules that have just been amended. So what I want to touch on is legislative change in Malaysia, where I recently was, that is actually quite major, and also major change in China. And the rules I'd like to touch on are the CIAC rules that have just been amended in 2025 and the HKIAC rules that were amended last year. And actually one of the things I wanted to say, because we have a very international audience, is just to give you an idea of where arbitration in APAC is going. And one of the things I want to say is, as a general trend, it is growing massively. So one of the things that may surprise participants who are not based in Asia is quite how new some of the institutions are and quite how many cases. So CIAC was established in 1991. That is the Singapore Arbitration Center, and HKIC in 1985. But they have grown really fast. So CIAC has released its statistics for 2023. They had 663 new cases, including related cases, and its second highest total sum in dispute ever at 11.9 billion US dollars. China, India, and the US remained amongst CIAC's top foreign users. They had 93 expedited procedure applications, of which 41 were accepted. So going back to what we've heard, Singapore and Hong Kong have had expedited procedures for a while now. Also, as regard diversity, it's something that we will speak about later. Of the 164 arbitrators appointed by CIAC, 60 or 37% were female. HKIAC is about to release its 2024 statistics. I think it's happening in February. I'm going to attend the event. But the 2023 statistics are out. They're on the website. They had 500 cases, of which 281 were arbitrations, of which 184 were administered, 10 were mediations. They also had 209 domain name disputes. The total amount in dispute in all arbitration cases was 12.5 billion. They also had 24 applications for expedited procedure under their administered rules, of which 15 were granted, 9 were rejected. In terms of the users, because I get asked about this a lot, the top 4 were Hong Kong, mainland China, BVI, and Cayman. In that context, you need to know that a lot of Hong Kong listed companies are actually incorporated in BVI and Cayman. As regards diversity, of 172 appointments made by HKIC, 60, so 34.9% were female, and 59, so 34.3% were not previously appointed by HKIC over the past 3 years. And I just wanted to give you an international context. So ICC had 890 new cases that year, and the SCC had 175 new cases that year. So I'm just trying to say that internationally speaking, both CIAC and HKIC are becoming very important, and the trend is upwards. In terms of major changes, so I think the trend that I'd like to draw worldwide is that there is a lot of competition for arbitration, and countries tend to update their legislation. As we've heard, the UNCITRAL model law is a very important reference point, but then there are also international best standards. So for example, in Hong Kong and in Singapore, we have legislation to allow third-party funding of arbitration. And And similarly, in some common law countries, for example, England, Singapore, and Malaysia, there are statutory adjudication regimes for certain kinds of construction disputes, partly to speed things up, and also partly to just allow the money to flow, because if money gets stuck in a major construction, it's a problem. Also, institutions worldwide periodically update their rules. So, for example, expedited and emergency arbitration. And also, in recent years, there's been a focus on data protection, not yet AI, but I think we've just heard it's coming, and diversity. So in Hong Kong, there is actually something that was passed in the 11th hour of 2024 in the context of construction. Namely, we had the Construction Industry Security of Payment Ordinance, which was gazetted, and it's basically coming very soon. So the big date is 28th of August, 2025. There's a lot of preparatory work trying to work out how adjudication will fit in. In terms of other major legislative changes, so in Malaysia, there is a plan to reform the Asian International Arbitration Center in KL. Basically, what they're trying to do, in a nutshell, is to set up a court of arbitration a bit like the ICC court. And there was a draft bill that was presented, which basically will replace the director of the AIAC with a new function, which is the president, and that sort of links back to the court. It is hoped that that will introduce more speed and transparency into the process. But I had a look at the bill, and it does some really interesting things as well. So we just heard about the law reform in the UK. Well, the proposal in the bill also is to have a default where the seat of arbitration defines the law of the arbitration agreement. So it's interesting how basically everybody's looking at what everybody else is doing because it's so competitive. The other thing that's happening is they seem to be about to allow third-party funding of arbitration, disapplying the doctrines which used to exist also in Singapore and Hong Kong, champity and maintenance, disapplying that for arbitration. So there's a trend here. The other major change that's taking place in my region is in China. So China has an arbitration law which dates back to the 90s, and a lot has changed since the 90s. The other thing that I've always found, because I do a lot of shipping arbitration, is Chinese arbitration tends to favor administered arbitration. And there are some major innovations underway in China that in certain contexts, for example, in shipping, will allow ad hoc arbitration to take place. And these changes in China will basically modernize Chinese arbitration law. And you see a lot of the arbitration centers, in anticipation of this law being changed, updating their rules. So for example, the Shanghai Center, SHIAC, has already updated its rules. The other thing that is really quite fundamental is the rules being updated. So SIAC, as I mentioned, has just updated its rules following a consultation, and they just came into effect this month, 1st of January. One major innovation I see is a cheaper, streamlined process that is available if the amount in dispute is under 1 million Singapore dollars, or if the parties agree. And that basically will tend to be written only, no hearing, no evidence. And I think that's really important, because one of the big problems of institutional arbitration tends to be the cost. They've also raised the limit for expedited procedure to 10 million. And what they've also done, and in Hong Kong, HKIC has done that, they've introduced what Kevin Nash called spine stiffening provisions to give arbitrators more confidence. So for example, spelling out that arbitrators can make a preliminary determination on an issue. They've also allowed for coordination between arbitration proceedings, where the same tribunal is constituted in 2 or more arbitrations. So this is just trying to make things logistically make more sense. One thing that also struck me about the new SIAC rules is in terms of the disclosure of third-party funding arrangements. which I think spells things out quite sensibly, but goes further than perhaps some other rules do. And basically, the tribunal can make orders for disclosure in respect of funding as it sees fit, including in respect of details of the funder's interest in the outcome and whether the funder has committed to undertake adverse costs liability. So basically, I guess it is highly relevant if a funder has not done that, because if the funded party has no funds, then they may not be able to pay costs at the end of the day. While disclosure and existence of a funding agreement on its own shall not be taken as an indication of the financial party status, the tribunal may take it into account in apportioning costs. So that kind of gives the tribunal something to hang on to when it is apportioning costs. Some changes that had been canvassed. So in terms of publicity of awards, I mean, with awards, there's always this problem. If awards are not published, then there are no precedents that can be referred to, which it is argued can impede the development of the law. So one of the proposals had been that awards would be published unless there was a kind of opt-out, and that actually didn't happen. There were also proposals to add additional grounds for challenge of arbitrators. And it seems that one of the additional grounds, which had to do with whether or not arbitrators fulfill functions within the prescribed time limits, I didn't actually see that in the final version. So it's quite interesting how these rules have changed. There tends to be consultation. In Hong Kong, there was a soft consultation, and then there was a written consultation. So they really take into account the feedback, and I think that is generally very positive. So the HKIC rules, there was a consultation and the rules were adopted slightly earlier, so last June. And one of the things that is notable is they actually put a provision in that requires the parties to consider, it's a soft provision, diversity when appointing arbitrators. We'll talk about that more later. There was also a fair amount of spine stiffening, so a lot of spelling out powers of arbitrators that arbitrators arguably already had, but by spelling them out, I guess the hope is that arbitrators will use these powers more. There's something in the HKIC rules about efficiency enhancing, including, for example, a time limit for declaring proceedings closed. I think it's 45 days, which time limit then triggers a deadline for issuing an award. And there is a new power actually for the HKIC to review and adjust tribunal fees and expenses, which is interesting. This is to try and, I think, catch some of the outliers, so sort of something that seriously went wrong. In both cases, modernized modes of communication are introduced. What the HKIC also does is it introduces ongoing disclosure requirements. So, for example, if parties change their legal counsel, that needs to be disclosed. This is sort of aimed at preventing conflicts of interest from arising. And both the SIAC and the HKIC new rules introduce clauses on data protection. There was something already to that in the LCIA rules. The SIAC and HKIC new rules are similar, but slightly different, but they basically enable the tribunal to adopt specific measures to protect shared data and address information security. I think a lot of this comes out of experiences from COVID, when everybody basically went virtual and we realized that we had to do this. And then something just happened 2 days ago in Hong Kong. There was a practice note on compatibility of arbitration clauses under the administrator's rules, which was issued. I think the short thing to note is when drafting arbitration clauses, it's always very smart to look at the model clauses. There is a new rule 29.2 in the HKIC rules, which basically allows for claims from multiple contracts to proceed under a single arbitration. And in that case, the parties will be considered to have waived even their right to select an arbitrator, and the HKIC will appoint the tribunal. But that doesn't necessarily address all of the provisions, all of the problems that might arise when there are multiple parties. So looking ahead, as I said to start with, it looks like Asian arbitration numbers will likely continue to increase. And that is actually, I didn't mention, but that's also the case in China. China has almost 200 arbitral institutions, and there is an increasing trend in terms of number of cases. I guess with the world changing, with the Trump inauguration earlier this week, it'll be interesting to see whether the kinds of cases that parties bring to Asia will change, the types of parties will change, and whether, trade flows will change, etc. So yeah, in my area, it's all about modernizing laws and rules. Thank you.
Thank you so much, Caroline, for that. I'm going to pivot quickly to Christina to hear about all updates from Brazil and Latin America. Christina.
So hi, everyone. It's my turn. Well, I will start saying that one important aspect to point out initially is that arbitration in Brazil is strongly established and it continues to grow. So we have more and more cases every year. So it's among the top countries globally in terms of number of arbitrations involving parties before the ICC. In 2020, Brazil ranked second worldwide. This was a huge number at that time. In the 2024 ICC report, Brazil figures as the fourth most selected country to be the seat of arbitration in 2023 with 34 cases. So I guess this reflects Brazil's growing use of arbitration for resolving commercial and foreign investors' disputes. So another thing that is important to point out when we speak about the arbitration scenario in Brazil is that 26% of the cases that are the proceedings in Brazil, they involve public administration. So as you know, Brazil is one of the few countries that do not use investor-state arbitration. So the disputes go to the commercial system. And since 2015, we had an amendment in the Arbitration Federal Act to give the express authorization that public entities engage in arbitration. And since then, we could really feel the increase of cases involving public disputes. Let's say that. So whenever there is a change in public administration, we face some risks. Yes, I guess that regarding the arbitration itself, the use of arbitration itself, it's not, so the use of arbitration is already so established that it's very difficult that a big change would come regarding to its use. But we can sense some changes in the use of arbitration by public administration, and this in two ways. Yes, one way is the use itself of arbitration in the contracts and public contracts, because there are always arbitrations that are more pro-arbitration, administrations that are pro-arbitration, and others that are not, others that just want to go to state courts. Yes, and the other risk is, and I think this is very common around the world, is that whenever there is a new public administrator, he or she will look into the contracts that were signed in the former administration and we'll try to reevaluate if that contract is still good, if it's not, if it was too expensive or so. And then sometimes, mostly for political reasons, the administrator decides to terminate the contract. Yes, so I think this is so common that we have had already 2 Vismut cases regarding this issue. Yes, the administrator that decides to terminate an ongoing contract. And So I think these are the two risks that are usually faced whenever a new administration comes in Brazil. We had so we had a federal a presidency election 2 years ago, and this risk did not happen. So the federal contracts continue to use administration and concession and public-private partnership contracts, even enhancing the use of it. And regarding termination of contracts, there are no big information. There's no information about that. So I guess it didn't happen. But we had last year, we had municipal elections and state elections all around the country. So they are starting their term now in January, and we will see what happens. I think that this kind of act to terminate contracts that were signed by the former administration is a potential risk. And the consequence is that there will be more disputes taken to arbitration, because all these big contracts nowadays, they use the arbitration agreement. So maybe we will see an increase in arbitration disputes in the next months regarding termination of contracts. But also, on the other hand, I must say that the good news is that there is a perception in Brazil that the political class has evolved in this regard, as also breaking a contract for purely political reasons can lead to accountability for the public official and responsibilities, which serves as a deterrent to radical actions. And also regarding to the use of the arbitration agreement and public contracts, there's also a very strong understanding that whenever you want the private sector to inject investments in infrastructure contracts, you need to use arbitration agreement. This is already a common sense in Brazil. So we are positive for this year, for the beginning of this new term, that no big changes will arise in the use of arbitration. So regarding legislative changes in Brazilian legislative scenario, there's no news. There were no legislative changes, no new laws about arbitration. What we had was a very important position taken by the Superior Court of Justice, very important decisions on some issues involving arbitration that really brought some clarity about some themes. I will just talk about two of them. One decided that, discussed the subsidiary application of the Brazilian Code of Civil Procedure to arbitrations. So we know that arbitration has its own autonomy, but this is an issue that frequently came in discussion. So to what extent the Civil Procedure Code will apply to arbitrations? And this decision, it was a case involving the Civil Procedure Code regarding the production of evidence invoked by one of the arbitration parties in an annulment action that it had filed. So, and the decision made it clear that it is up to the arbitral tribunal to determine how evidence will be produced in arbitration in compliance with the chosen arbitration rules. So because the case was discussing about the application of the Civil Procedure Court related to the producing of evidence. So this was an important decision. And another landmark decision, the Superior Tribunal, Superior Court of Justice addressed the duty of disclosure, emphasizing the obligation of the parties to cooperate in the process by indicating the information and facts they would like to see addressed by the disclosures provided by the appointing professional. So this is also a very important decision. And additionally, the court established an important precedent by ruling that the mere non-disclosure does not automatically lead to the annulment of an arbitral award, that an analysis of the relevance of the undisclosed fact is necessary to determine the outcome of the annulment action. Another important fact in Brazilian scenario is that in December, the Brazilian Senate ratified an international agreement that was signed in 2017, making Brazil one of the seats of the PCA, the Permanent Court of Arbitration. And also, as Caroline told about what happens in Asia, the arbitration institutions in Brazil are also constantly improving their rules. In 2024, several of them issued specific rules for the early production of evidence in arbitration, without the necessity of addressing a state court. And now about the current state of arbitration in other South American countries. I selected to talk a little bit about Peru, Uruguay, and Argentina. Peru is a country where arbitration is also very, very strong, even with public administration. And on September, there was enacted a legislative decree amending the decree that regulates arbitration. And the purpose of the decree was to strengthen transparency and legal security in arbitration through the mandatory registration of arbitration centers and arbitrators in the National Registry of Arbitrators and Arbitration Centers for public information purposes. So this, there was a huge discussion in a Peruvian scenario because despite its positively describes the objectives that were positively described, the decree faced resistance, and it issued so many arbitral institutions such as ICC, AmCham, CCL issued a manifesto titled "No to State Interventionism in Arbitration." And the critic targets the registration system itself, arguing that it has contributed to the proliferation of arbitration institutions that fail to meet minimum quality standards. And also it imposes excessive bureaucracy on arbitrators. So it's what is also important to point out is that Peru continues to be amongst the countries with the highest number of new cases before ICD. And maybe a possible reason could be the legal instability that government changes occurred in the last years may have generated. So Peru, they had, I don't know how many changes of presidency in the last years, and that probably sent a message of legal instability leading to increase in investment state arbitrations. Uruguay also faced a domestic arbitration impact. The arbitration law suffered big reform. One important thing to point out is that it modified Article 493 of the Civil Procedural Code to insert a prohibition of judicial interference in the course of administration. So judges are now prohibited from ordering the suspension of an arbitral proceeding under the strictest functional responsibility. The rule also says that the suspension of arbitration cannot be ordered due to a primary judicial process, nor as a judicial precautionary measure, nor through an amparo action, nor by any other judicial procedure. So this is also a measure that strengthens the importance of arbitration. And finally, in Argentina, So in Argentina, there was a few years ago the new elected president, Javier Milei. He proposed profound legislative reforms to try to recover from the deep economic crisis faced by the country. And one of the proposed laws expands the scope of arbitration as a conflict resolution mechanism. And also a key point is the modification of the regulatory framework for investments, strengthening investors' protection and explicitly recognizing the validity of arbitration clauses in international contracts. And there is also another piece of legislation, the Ley de Bases para la Reconstrucción de la Economía Argentina, for the reconstruction of Argentinian economy, which amongst other aspects promotes more efficient dispute resolution mechanism, specifically regarding the investments. It expressly recognized the possibility of submitting disputes to international arbitration, especially in cases of foreign investments. And also in the state reform and privatizations that the government wants to conduce, the arbitration is the way of solving disputes, means that is chosen. So I guess this is it. There was a lot more to talk about, but let's keep the limited time that we have.
Thank you. Thanks, Christina. I know this is going to have to be a two-parter. Maybe we can corral and persuade this group to come back for part two. So Zaina, I'm going to turn to you for updates from the Gulf and the Middle East.
Thank you, Kristen. I'm delighted to provide this overview of the recent development in the MENA region. Of course, I will not address all the jurisdiction. I will only focus on those that have showed and witnessed notable changes. So as you all know, in 2024, some countries in the MENA region experienced a political turmoil, but others saw a remarkably dynamic year on the arbitration front with a lot of developments. And I will mainly focus on my presentation on the developments on the investment treaty arbitration front, institutional arbitration, and if we have time to highlight some recent court decision, mainly in Dubai and in Qatar. So with respect to investment treaty arbitration, if we start with Egypt, since 2011, with the Egyptian revolution, Egypt has been receiving not less than 26 arbitration cases. And in 2024, they managed to bring down the cases to just one. And we will see now whether this will be shifted in 2025. I have a series of cases that occurred in Egypt in 2024, but maybe I will skip this due to the time constraint, but I'm happy to discuss this later on. In Jordan, the National Electric Power Company, NEPCO, lost an ICC claim brought against a joint venture, and that was about an alleged overpricing of electricity tariffs by the operator. In Kuwait, for the first time in history, an exit committee annulled an award under the Center Expedited Dismissal Procedure. It was a claim of $320 million claimed by an Egyptian investor over a land in Kuwait. In Lebanon, which is still suffering from the economic crisis since October 2019, so as very briefly, the Lebanese bank imposed a de facto capital control, and which resulted in two types of currency in the country, what we called lullers and dollars. So depositors do not have access to what we call their lullers funds. So this, among other, prompted to the Emirati Al Habtour Group to issue a notice of dispute under the UAE Lebanon BIT, claiming the Lebanese central bank it froze its funds, and maybe other investors might also file claims on this ground. Another case that was notable in Lebanon in summer 2024, a Greek investor, the Lebanon defeated a Greek investor claim of 417 million euro over the construction of an electricity plant. In Libya, in 2024, Libya resisted several enforcement proceedings before the French courts. One against a Turkish contractor, it was a 20 million USD award, and a second award again in favor of a Tunisian investor, 280 million euro. I will not go into the details, but just as a brief update. And in Sudan, in July 24, the third exit case was filed in relation to a debt financing agreement, which was filed by the Qatar National Bank. So this is a quick overview of what's going on in the region from the investment side. And now I would like to turn to the second topic, which is institutional arbitration. I'm not addressing legislation because no significant update happened in the region. Most of the laws have been in the past year reformed, and they are shaped based on the UNCITRAL model law. In Saudi Arabia, there are some specificity with respect to Sharia, but overall, everywhere, and except Lebanon, where the arbitration law is based on the French law, most of the laws are UNCITRAL based. No specific reform have occurred. But on the institutional arbitration front, there was a big dynamism on 3 levels. The first level is the implementation of new arbitration institutions, such as Arbitrate AD in Abu Dhabi, which was launched on 1st February 2024. They have issued a new set of arbitration rules, a new court, new secretariat. And this institution is actually a reorganization of the previous ATCAC institution, which was quite criticized because it was not really performing. Second, many arbitration institutions also updated their arbitration rules. This is the case of the KICA in Qatar, the Qatar Arbitration Center. They have just published their new rules on 1st of January 2025. Similarly, the Cairo Regional Center, just a few days ago, they've issued their new 2024 rules. They are enforced now as of 15 January 2025. And these rules are based on the UNCITRAL rules, and they include several updates, such as emergency arbitration. They've included joinder and many other provisions. And lastly, on this front, on the institutional front, we have seen really a trend and an interest for institutions to cooperate and collaborate with other regional and international institutions, which is great for collaboration. So for example, the SCCA, which is the Saudi Arbitration Center, and ICSID signed a cooperation agreement to jointly promote arbitration and other ADR models. Also, the SCCI signed with SIAC an MOU to organize conferences and seminars and workshops on arbitration in Saudi and Singapore. And in Bahrain and Singapore as well, they've signed in March 2024 a bilateral treaty to establish a new Bahrain International Commercial Court. And there is also a body in Singapore that will hear the appeal from this court. So this is really an interesting development of what's going on in the region. And now quickly, if I still have some time, regarding the recent court decisions that have shaped the UAE the past year, and it was a topic of discussion in the arbitration community. First is the recovery of legal fees. It has been subject to controversy in recent years, The Dubai courts often partially set aside awards that ruled on legal fees if the institutional rules were silent and the parties did not expressly agree that the costs of arbitration include the legal fees of the council. And this started with the previous 27 DIAC rules, which was silent on this issue. So this triggered a series of partially annulled award on this ground. Although it has this gap has been remedied by the 2022 DIAC rules. Despite this, and on 5 February 2024, in an ICC arbitration, the Dubai courts also partially annulled an award on the basis that both Article 46(1) of the UAE arbitration law and Article 38 of the ICC rules do not include and refers to legal fees, which was quite surprising, especially because the ICC rule include the legal fees. So fortunately, by the end of last year, on 19 November 2024, the Dubai Court of Cassation reversed its position and clarified that the ICC rules include legal fees, and then the award should not be set aside on this ground. Another point of controversy is the notion of seat of arbitration. In 2023, there was a surprising decision from the Abu Dhabi Court of Cassation. It was an ICC arbitration seated in Abu Dhabi. A challenge was filed before the Abu Dhabi courts, and the Abu Dhabi courts said that they are not competent to hear the dispute because the ICC is based in ADGM. ADGM is an offshore virtually called in Dubai's free zone offshore jurisdiction, mainly governed by common law. So ADGM courts should be competent to hear the dispute. So fortunately, the Dubai Court of Cassation also on 19 November 2024, by the end of last year, rendered a very welcome decision clarifying the notion of seat of arbitration, and that the fact that an institution is based in a free zone or wherever it is based, it does not affect the seat of arbitration or the competence of the court according to the seat. And another important update is regarding the specific issue of the validity of arbitration agreements that designate the DIFC-LCIA as the institution that will administer the dispute. I don't know if some of you know, in 2021, the government of Dubai issued a decree abolishing all institutions, including the DIFC-LCIA, and transferred all the case to DIAC, the Dubai International Arbitration Center. So at that time, an issue, especially from the legal community, concern was, what about parties' autonomy? How this arbitration clause will be valid? The party did not necessarily agree on DIAC, and how the court will approach this question. So this has been raised, and recently the Abu Dhabi Court of Appeal in 2024 unsurprisingly considered that these arbitration agreements referring to DIFC-LCIA are enforceable, and that DIAC is the successor of DIFC-LCIA. And also the DIFC courts, Judge Michael Black also held that the decree did not render this type of agreement void. However, this is not this is not shared by other courts abroad, like in the US and in Singapore. In US, the Louisiana District Court, when dealing with the question of the validity of such an arbitration agreement, stated that the court cannot rewrite the parties' agreement, neither the government of Dubai, and that DIAC and DIFC LCIA are not the same forum. Since DIFC LCIA is no longer available, then we cannot compel a party to arbitrate. And Singapore kind of held the same reasoning at the enforcement level of an award, and stated that we cannot compel a party to arbitrate under a set of rules upon which they did not agree. However, in this case, the award was enforced because the court raised that the respondent did not raise an objection on the validity of this arbitration agreement during the course of the arbitration proceedings, and accordingly, respondent waived its rights to such objection. So this is really interesting also to see how other courts at the enforcement level will deal with the situation. So arbitrators at council needs to be careful when they are faced with such clauses. And very quickly, I would like to talk about in Qatar about an interesting case, which is interest.
Zaina, I'm so sorry to cut you off. This has just been a wonderful update, but I'm recognizing we're already at time, and I want to give the last 10 minutes, if folks can bear with us, to go over our time here to Githu for some updates from Africa. But I want to plug again the forthcoming Resolver special issue, and I think we can definitely look forward to extending those updates. So thank you so much, Zaina. I'm going to turn now to Githu for updates from Africa and a focus kind of on some ethics and standards issues developing there. So Githu.
Thank you very much. I'm going to be very brief because we've run out of time. Africa, as we all appreciate, is a continent, is a very large place with very diverse countries. And with very diverse legal systems, but I will try to treat it as one for purposes of the themes that I will treat. The first thing I'd like to say is that ADR and arbitration in particular is growing at a very healthy pace. If for no other reason, if you look at the number of institutions that have not only been set up, but are now robustly thriving. Africa now boasts of very, very strong institutions in South Africa, in Kenya, in Nigeria, in Egypt, in Rwanda, and in Mauritius. In fact, in Cairo and Johannesburg, we are told that the standards that have been achieved are fairly impressive. As one who practices in Nairobi and in the region, including Rwanda and East Africa region, I can say that both Nairobi and Rwanda are very good institutions and attracting a lot of attention. The other thing that is happening on this continent, which is really important, is the recognition that we can have an ADR system that is annexed to the courts. In Kenya, for example, there is mandatory ADR, which is court annexed. And so there are very many disputes, especially in the area of family law, succession and related areas, and small claims that must be mediated as a matter of legal requirement. In that regard, I have noted that this ADR policy that has worked well in Kenya is being borrowed in the region. It's been borrowed in Zambia, in South Sudan, and in other places, and it is beginning to function very well. Out of the COVID nightmare, we were able to rescue ADR as a system of dispute settlement, and as a result, we have a very robust ADR system that is around a whole range of areas, particularly in the areas of commercial disputes and construction disputes and so on. And the second thing that is happening in Africa that is quite exciting is that upon the conclusion of the African Continental Free Trade Area Agreement, there is a continental-wide there's continental-wide energy towards economic integration and free trade. And the consequence of that is that it comes with the desire to localize dispute settlement so that it is efficient, cost-effective, and so on. And we are very excited. We in this area are very excited at the possibilities. Now, for a long time, not every country on the continent, especially because, as I've said earlier, we have very diverse legal systems. The model law was adopted largely in Commonwealth, common law countries, English-speaking countries on the continent. But this is now beginning to spread. And we have a large number of law reform initiatives. Some countries joining the model law, some countries revising the model law. We've seen activities in Nigeria and Malawi around rejuvenating the arbitration law. We have seen a lot of activity in South Africa around strengthening the arbitration institutions. Something else that is happening also, again, out of COVID, we were able to rescue technology. We have leapfrogged in the use of technology because of the crisis that COVID brought. And I can tell you that in my own practice, virtually all preliminary pre-arbitration work is done online. That has increased the number of cases we can resolve. It has cut costs enormously, made arbitration more attractive, because one of the problems, of course, globally is that arbitration is viewed as promising a cost-effective procedure, but producing something slightly different. So we have that, and it's helping a lot. We have a better dialogue between the courts and the arbitral tribunals and arbitral institutions. The judiciaries in Africa are beginning to support the arbitration process more robustly, and that's a very, very positive development. In particular, the courts continue to be deferential to the arbitral tribunal, but retain sufficient oversight so as to avoid any abuse of the arbitral process. We are still trying to come to terms with a number of problems, like has been said about other former common law countries like Hong Kong. With third-party funding, the debate is on. We have not yet found, there isn't a legislative intervention yet, and that debate is ongoing. We are continuing to grapple, and this is my last point. We are grappling with the issue of the professional ethics around arbitrators and arbitral tribunals. Africa has produced two of the most notorious cases: the Kenya duty-free case, which all of you are familiar with, which was an ICSID arbitration, and only so very recently, the Nigerian case, which we are all familiar with, where English courts have had to intervene in what was clearly a very unethical process in what one would have thought was a case that was in the hands of very eminent arbitrators of international standing. So that reminds all of us that we need to be concerned about this particular problem. And in Africa, we are going back to the institutions trying to create a regulatory framework where after post-appointment, the institution can still retain oversight on how the arbitrations are being conducted. I'll stop there because of time, but next time when I am the first to speak, I will have more things to say. Thank you very much.
Thank you so much, Githu. And thank you to all of our speakers, and thanks for all of our attendees for staying with us over time. I think this could have been a full day conference. I was ready to, dig into every single topic. We'll come back to you on maybe a part 2 if we can spare the time of this group to get together again. But I just want to say huge thanks to our wonderful speakers and experts. And I should have known, given the high caliber of experts we have, that we would never have time to get through all the updates from around the world. But thank you so much to each of you for sharing. Extremely helpful and informative. And we will look forward to sharing out your Resolver kind of written pieces that accompany this webinar. So thank you so much for the time. Thanks to all of our participants and folks who joined online, and look forward to seeing you in the future. So thank you all so much.
Thanks, Kristen.
Thank you, Kristen.
Thank you. Bye.
Thank you. It's been a pleasure.
Thank you.
Thank you very much. Bye-bye.